Major breaking news out of Maryland. The United States Court of Appeals for the Fourth Circuit, one of the worst courts in America for respecting the Second Amendment's right to keep and bear arms, has decided to grant en banc review of the earlier Maryland shall issue versus Moore case dealing with knocking out the Maryland handgun qualification license. Let's talk about this unfortunate but not unexpected turn of events with the insane and terrible Fourth Circuit Court of Appeals when it comes to our right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundy Awards for top gun tubers, if you will. One in the category of top male influencer in the Second Amendment space, and the other category, top voices of the Second Amendment. I am proud to be a finalist in both Gundy categories. All right, folks, so news, big news, but not sort of unexpected news. Unfortunate, but not unexpected. The United States Court of Appeals for the Fourth Circuit, one of the worst courts in America for our Second Amendment rights, up there in competition with the Ninth Circuit in many respects and the First Circuit out of Boston. The Fourth Circuit has granted en banc review, meaning they're going to review a major Second Amendment victory in the case of Maryland shall issue versus Wes Moore, the governor of Maryland. And if you may recall, we did a video on this. We talked about this before. I also wrote an article in AmmoLand about this case. Specifically, a couple months ago, the Fourth Circuit Court of Appeals panel, which is a 3-judge panel, in a 2-1 decision concluded that Maryland's handgun qualification license, which was unduly onerous and unconstitutional under Bruin because there was no historical analog for this at the time of the founding. This infringed the right of the people to keep and bear arms. As a textual matter, the burden then shifted as it must under the Heller-Bruin methodology to the government to come forth with some historical analog laws that are well established and long-standing and representative at the time of the founding to justify this handgun qualification license in order to get a gun, a handgun. In fact, before you can even submit an application to concealed carry, for example, in Maryland, you must first get a handgun qualification license, which consists of submitting fingerprints, background checks, a 4-hour-long firearms safety training course, firing at least one live round, and a wait up for 30 days for approval before you can start the rest of the process, which of course is to go get your concealed carry permit. So this handgun qualification license was struck down by the 3-judge panel back, I think, in late November, 2-1 decision, and the Fourth Circuit ruled that indeed, at a preliminary level, this handgun licensing rule was unconstitutional, which was a major win for the Second Amendment. Specifically, the Fourth Circuit held that the right of the people to keep and bear arms shall not be infringed, and as a consequence, because this restriction makes it harder, provides an obstacle, creates a hindrance to the ability of Americans in the state of Maryland to be able to keep a firearm or a handgun, to bear, meaning to carry a firearm or a handgun in that state. This constituted a textual infringement, as in the right of the people to keep and bear arms shall not be infringed. And because the handgun qualification license by Maryland constituted an infringement, that was presumptively unconstitutional. The Fourth Circuit panel then turned their attention and said to the state of Maryland, okay, you tell us what historical analog law at the time of the founding can you point to that's well established and was somewhat ubiquitous, meaning everywhere at the time of the founding, that would somehow justify these kind of onerous licensing requirements on people that wanted to acquire firearms, i.e. handguns in the case of this handgun qualification license in Maryland. And of course, the government could come forth with nothing to support their argument. The 2 major arguments the government of Maryland came forth to try to justify their handgun qualification license, which was ultimately rejected by the panel. First one is they try to argue that these crazy onerous licensing rules prevent dangerous people from getting the guns. But the panel said, wait a minute, but there's only additional restrictions if you're first found to be dangerous. This is not what the Maryland law is doing. This Maryland law is applying to all Maryland residents, whether they're dangerous or not. So you're putting a burden on people that have nothing to do with dangerousness, that have never been found to be dangerous. There's no reason to think they're dangerous. So therefore, any laws restricting the ability of dangerous people to get guns at the time of the founding are not historical analog laws dealing with what Maryland's doing here, which is basically creating an onerous restriction upon all Marylanders, including those that are not dangerous. So that analog law was rejected. The second thing was there was an attempt by the state of Maryland to use militia laws, but as you know, militia laws were different than the ability of an American to keep and bear arms, because yes, if you were part of the militia and you showed up for militia duty, at that time there were certain things you might have to do. Bring certain weapons, bring certain ammunition, bring cartridges, march in a particular way, appear in a particular way, in a uniform or not in a uniform, whatever it is. But those were militia rules associated with members of the formal militia when they mustered. The state of the Fourth Circuit in the Maryland Shall Issue case versus Moore said that's not historically analogous, because what we're talking about here with the Maryland handgun qualification license is it's a license for anyone in the state of Maryland to be able to get a handgun and to carry a handgun, not just those people that were serving in the militia while they're doing the militia service. So anything associated with dealing with running a militia does not speak to all Americans, because at the time of the founding in 1791, when the Second Amendment was adopted, keep in mind there was no kind of restriction like this that would apply to Americans just wanting to get guns for home defense or for self-defense or whatever. Again, there may have been rules associated with the militia duty, but that presumed that you were in the militia and that you were at militia duty serving when those restrictions would apply. They would have no bearing on ordinary Americans just wanting to own guns privately for their own private purposes on their farms, in their homes, in their houses, whatever. So therefore, the Fourth Circuit panel said, clearly, those are not analog laws that can justify Maryland's handgun qualification license. So the bottom line is this. Today, the Fourth Circuit issued, there was a request for en banc review by the governor of Maryland, and this is what the order from the Fourth Circuit said. It says, a majority of judges in regular active service and not disqualified having voted in a requested poll of the court to grant the petition for a rehearing en banc, it is ordered that rehearing en banc is granted. This case is tentatively scheduled for oral argument during the March 19th through March 22nd, 2024 oral argument session in Richmond, Virginia. Now, what's also weird about this is we're still waiting for the Bianchi quote-unquote assault weapon case, the assault weapon ban case out of Maryland to be decided. That had an oral argument over 1 year ago. And yet there's no decision by the Fourth Circuit. So what I have speculated, and this is just speculation on my part a couple months ago, is that it seems to me what is happening is the United States Court of Appeals for the Fourth Circuit may have recognized that a panel decision was going to come out in favor of the Second Amendment, knocking out Maryland's quote-unquote assault weapon ban, which is a ban on semi-automatic rifles. And that what's happened internally to the Fourth Circuit is that the Fourth Circuit has decided to en banc the case internally, unbeknownst to anybody in the outside world, and have decided to issue a ruling saying that people like the governor of Maryland and states can ban AR-15s and semi-automatic rifles. I don't see any other explanation to justify the delay of the Bianchi case. So here you have the Fourth Circuit Court of Appeals going out of the way again to try to throw Second Amendment supporters and gun owners under the bus and to treat the Second Amendment as a second-class citizen. And the delay in the Bianchi case may also be part of this ploy by the United States Court of Appeals for the Fourth Circuit, which has an overwhelming number of terrible anti-gun judges, including Republicans such as Harvey Wilkinson III, an elderly judge who probably should have taken senior status during the Trump administration, so someone could have replaced him with a young, more constitutionally focused, originalist kind of judge than Harvey Wilkinson. But nevertheless, that did not happen. So, even the Republicans such as Judge Wilkinson are terrible on the Second Amendment, in addition addition to the typical off-the-shelf liberal judges that you can, grab out of any American law school to rule in the right way, in terms of the right way being for the progressive left in America. Nevertheless, here's where we're at, so we'll keep you apprised during that oral argument at the end of March in the Maryland Shall Issue versus Moore case dealing with the handgun qualification license. And of course, as soon as we hear something out about the Bianchi case dealing with Maryland's quote-unquote assault weapon ban, which is now pending in the Fourth Circuit, we will, of course, bring that to you as soon as we hear something. But in the meantime, I hope you've learned something from this video. Don't forget to subscribe and follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.